Welcome to Srmvnews. Supreme Court limits capacity to uphold Miranda privileges. The Supreme Court restricted the capacity to uphold Miranda privileges in a decision Thursday that said that suspects who are not cautioned about their entitlement to stay quiet can't sue a cop for harms under government social liberties regulation regardless of whether the proof was at last utilized against them. In their criminal preliminary, the court's decision will scale back a singular securities against self-implication by notwithstanding the possibility to acquire harms. It likewise implies that the inability to control the advance notice won't uncover a police officer to expected harms in a common claim. It won't influence, in any case, the prohibition of such proof at a criminal preliminary. The court explained that while the Miranda advance notice safeguards a protected right, the actual admonition is definitely not a right that would set off the capacity to bring a common claim. The present decision doesn't dispose of the Miranda right, said Steve Vladeck, CNN Supreme Court examiner and teacher at the University of Texas School of Law. Be that as it may, it makes it far harder to implement. Under this decision, the main solution for an infringement of Miranda is to stifle proclamations got from inappropriately educated suspects with respect to one side to stay quiet. Be that as it may, assuming that the case never goes to preliminary, or on the other hand assuming that the public authority never tries to utilize the assertion, or on the other hand assuming the explanation is conceded despite the Miranda infringement, there's no cure by any stretch of the imagination for the public authority's wrongdoing. Equity Samuel Alito, joined by the 5 other Republican-designated judges, said that an infringement of the Miranda right isn't itself an infringement of the Fifth Amendment, and that we see no legitimization for growing Miranda to present an option to sue, under the important resolution. Equity Elena Kagan, joined by the other liberal judges, said that the court's decision was stripping people of the capacity to look for a solution for infringement of the right perceived in Miranda. The larger part here, as somewhere else, harms the right by denying the cure, she added. The case included Terrence Tecco, a medical clinic laborer, who was blamed for physically attacking an immobilized female patient at a nearby emergency clinic in 2014. At issue was not whether a litigant should be perused his Miranda freedoms, however whether he can sue an official for harms on the off chance that he doesn't get the Miranda cautioning for proof presented in a lawbreaker. Continuing, lower courts have parted on the issue. Carlos Vega, a Los Angeles County Sheriff delegate, addressed Tecco, in spite of the fact that he neglected to tell him his options as expected by the 1966 point of reference of Miranda v. Arizona, where the court held that a respondent should be cautioned of a right to stay quiet. Under that point of reference, without the Miranda advance notice, criminal preliminary courts are for the most part banished from conceding self-implicating proclamations made while the litigant was in guardianship. Tecco at last admitted to the wrongdoing, was attempted and cleared, even after the presentation of his admission at preliminary. Afterward, he sued the official under a bureaucratic regulation, Section 1983, that permits suits for harms against an administration official for disregarding established privileges. The gatherings differ on whether Vega utilized coercive methods to extricate a compulsory admission. Legal counselors for Vega said Tecco's proclamation was totally consensual and deliberate, and he was not in fact in guardianship at that point. While Tecco's attorneys battled, he was harassed into admitting in an austere room. Roman Martinez, a legal counselor for Vega, said that Tecco couldn't bring his case in light of the fact that laying out an infringement of Miranda doesn't lay out an infringement of the Fifth Amendment. Miranda makes a procedural rule banishing examiners from presenting and courts from conceding certain unwarned proclamations as a piece of the arraignment's case in boss at a criminal preliminary, Martinez contended in court papers. 4. Martinez, the Miranda cautioning is a protected rule, it's anything but a right, and under that translation the claim can't proceed. Miranda doesn't deny taking unwarned explanations, it just disallows the resulting affirmation of such articulations at preliminary, Martinez contended. He said a requests court deciding that went for Tecco would saddle police divisions cross-country with remarkable weights regarding legal and suitable insightful work. Any police cooperation, as per Martinez, could lead to a confidential claim even where the cop has acted completely legitimately. The Biden organization agreed with Vega. Since the Miranda rule concerns the presentation of proof at preliminary, a suspect may not sue the cop under Section 1983 for disregarding that standard. Solicitor General Elizabeth Prelogar contended in court papers. Legal counselors for Teko contended that Vega would not acknowledge Teko's disavowals and that with a hand laying on his gun, Vega took steps to report Teko and his relatives to movement. Teko has a green card, and removal could prompt mistreatment in Cameroon. Since the Miranda rule concerns the presentation of proof at preliminary, a suspect may not sue the cop under Section 1983 for disregarding that standard, Solicitor General Elizabeth Prelagar contended in court papers. Legal counselors for Teko contended that Vega would not acknowledge Teko's refusals and that with a hand laying on his gun, Vega took steps to report Teko and his relatives to migration. Teko has a green card, and extradition could prompt mistreatment in Cameroon. Paul Hoffman, a legal counselor for Teko, said that Vega was the focal entertainer in the chain of occasions driving straightforwardly to the assertion being presented at preliminary. Thanks for waiting.